In England and Wales, the Divorce, Dissolution and Separation Act 2020 removed the requirement to prove fault or assign blame to end a marriage. Because fault is no longer a factor, the entire procedural journey is now strictly driven by statutory timelines. Before you can even start that clock, you have to meet 4 strict prerequisites. The couple must have been married for at least 1 year. The applicant must have attended a mediation information and assessment meeting or hold a valid exemption. You need the original marriage certificate, and you must pay the court fee, which is currently £593. Failing to secure even one of these prerequisites stops the application before it begins. Clearing them is your first critical hurdle. Let's look at the absolute time bar under Section 3 of the Matrimonial Causes Act 1973. A court will reject any application made within the first 365 days of a marriage or civil partnership. Next, the court expects parties to attempt alternative dispute resolution. The applicant must attend a MEAM or secure a formal exemption signed by a mediator before the application is filed. When filing, the old terminology has been retired. The person filing is now the applicant, not the petitioner. The 2020 Act also allows both spouses to file together as joint applicants. Deciding whether to file as a sole applicant or jointly dictates exactly how the upcoming service phase will operate. The application itself now hinges on a single core declaration, a formal statement that the marriage has irretrievably broken down. There are no behavior or separation facts to prove. Legal professionals issue this application through the mandatory MyHMCTS digital portal. Litigants in person still have the option to use the traditional paper, Form D8. The application must be accompanied by the marriage certificate, the court fee, and a statement confirming whether reconciliation has been discussed. Once the court accepts and issues the application, a rigid 20-week statutory cooling-off period officially begins. After issue, the application must be served. The court typically handles this by email, though first-class post or a bailiff are available if email isn't possible. Once served, the respondent has exactly 14 days to file an acknowledgement of service. If they wish to dispute the divorce, they must file an answer using Form D8B. However, the grounds for defense are strictly limited to contesting the court's jurisdiction or the legal validity of the marriage itself. Under the no-fault rules, a respondent cannot block a divorce simply because they disagree with the breakdown. Their ability to object is purely technical. Now we enter the first major waiting period. The statute enforces a 20-week pause designed to give the parties time to reflect and negotiate financial arrangements. You can only apply for the next stage, the conditional order, after exactly 20 weeks have passed from the date the initial application was issued. If you filed a joint application, there is a procedural trap to watch for. If one party fails to complete their part of the acknowledgement within 14 days, the entire process stalls. To fix a stalled joint application, the proactive party can formally switch the case to a sole application to keep things moving. The 20-week wait ensures adequate time for deliberation, while switching to a sole application prevents an uncooperative spouse from holding the legal process hostage. The final step in the process is securing the final order. This is the legal mechanism that officially dissolves the marriage or civil partnership. The second statutory waiting rule applies here. You can only apply for the final order 6 weeks and 1 day after the conditional order is pronounced. You have a 12-month window from the conditional order to make this application in time. Missing this deadline requires additional explanations to the court. If the applicant secures the conditional order but delays applying for the final order, the respondent gains the right to apply for it themselves. They can do this after a further 3 months have passed. The final order is never automatic. Failing to track these exact deadlines can shift control of the finalization process over to the opposing party. This diagram maps out the unbreakable statutory sequence. You file the application, wait exactly 20 weeks for the conditional order, and then wait another 6 weeks and 1 day for the final order. Without the need to prove fault, a practitioner's success is entirely measured by hitting these specific dates and filing the correct digital forms. Mastering this sequence ensures you navigate the online portal smoothly and manage your client's expectations from the very first meeting all the way to the final order.